Welcome to Supported Decision Making in North Dakota. How to be a supporter. This presentation is not meant to give legal advice. Each situation is different. Please contact a lawyer if you would like legal advice. Why do people choose supported decision making? It's about helping people with disabilities ask for only the help they want. It gets and keeps everyone in a lane as a supporter or as a decision maker. This helps keep decision makers in control of their decisions, and it tells supporters what kind of help and how much help is helpful. How can you encourage and build on an individual's decision-making skills in your work as a supporter? Let's find out. We'll start with supporter basics. First and foremost, you are a helper. So what does that mean? It means you're going to say things like, "What do you need from me?" Or "What can I do to help?" Versus, "This is what you should do," or "This is what I would do," or "How about let's do this," or "This is what I think." www.supporteddecisionmaking.org has a brainstorming guide, which is a great resource. North Dakota Protection and Advocacy has also developed a worksheet available on its website to help individual decision makers work through what kinds of decisions they may want to make and how they want to make those decisions. Supported decision-making agreements are not intended to be permanent. Trial and error is okay. You live, you learn. No decision is too big or too small. Supported decision-making is different from guardianship or substituted decision-making. In SDM, the supporter does not have any decision-making authority and cannot sign documents on behalf of an individual. Supporters should not be influencing the individual's decisions. It's not about the supporter. Qualities of a good SDM supporter include being a good listener, being able to understand the individual you're supporting and their values and preferences. As a supporter, you should be able to gather and understand information. You should also be able to follow directions without judgment and put aside your own values and beliefs. You should be able to assist even when the decision seems risky or unwise. This is called dignity of risk. There's a separate presentation available if you'd like to learn more. Finally, you should be able to communicate decisions clearly on behalf of the individual you are supporting. And remember, supporters can't make decisions. Knowing the person you are supporting and their disability or disabilities is fundamental. Think about, how does the individual communicate best? Is that in writing? Is it speaking aloud? What kind of information is most meaningful to them? Is that reading? Do they learn best from watching videos or going places and learning things that way by demonstration? What is the person's understanding of the decision? One easy way to check this is to ask, "What did we just talk about?" and listen to their answer. You might identify areas that need additional support or explanation. Try to avoid asking, "Do you understand what we just talked about?" You can also ask, is there anything else the individual wants to know? Or if they would like more time or time at all to make a decision, and if so, how much? Ask if there's someone else the individual would like to talk about the decision with. Because as a supporter, you might not be their only trusted person, and they don't have to take your advice. Consider using assistive technology. When you are supporting someone, focus on the decision-making process, the how, and not the outcome, the what. For example, if an individual you are supporting says, "I want to move out," a great response to that is, "What I'm hearing you say is you might want supports in deciding where else you'd like to live," which is better than just an okay response of, "Do you want someone to help you choose another apartment?" What's happened in that second, that just okay response, is when you say, "Do you want someone to help you choose another apartment?" you've bookended their decision. Whether that was intentional or not intentional, You may have limited them to choosing another apartment where maybe they didn't want to move to an apartment, or maybe they actually didn't really want to move out. If you had responded with, "Tell me more, tell me what's going on," maybe you'd figure out that they had a neighbor that was watching TV too loud, and it was something in the environment which you could help them address if they wanted your help. So always focus on open-ended language and make sure your words aren't in any way limiting the kind of decisions that are on the table. Remember to check if you know what matters and what matters to the person you're supporting, not what you think matters. You can do this by using reflective listening. For example, saying, "What I'm hearing you say is," and then listening to their response to see if you've gotten it right. If you didn't, try it again. Get feedback. Ask the person you are supporting these questions on a regular basis. How am I doing as your supporter? Do you want me to do anything differently? And make any needed changes, keeping in mind the person's preferred way of communicating with you. Support asked for and given will look different for every individual. Remember, you, the supporter, are not deciding anything. You shouldn't have any skin in the game. It's important to talk with the individual you are supporting and include in your discussion the agreement boundaries. What kind of areas are being supported? What the support you are giving looks like, and how the agreement may be ended. Remember in the beginning, we talked about how supported decision making gives everyone a lane? Your job is to stay in your lane as a supporter. You may want to help. Make sure the person wants your help, and if needed, change the SDM agreement to reflect that. A supported decision making agreement can be a big deal for many individual decision makers. It may represent the first time that individual has ever felt the power of choice, and it's a reason to celebrate. Take that paper, take some selfies, have cupcakes, blow up a few balloons, whatever it takes to honor the occasion. The person you are supporting has a lot of flexibility in supported decision making. They can have you as a supporter. They can ask other people to be their supporters. They don't have to listen to any of their supporters' advice. This same flexibility is carried into how SDM agreements terminate or end. For the person being supported, they can tell you. They can use an assistive technology device. They can use any other action showing intent to terminate or end that agreement, such as scrumpling up the paper and throwing it in the trash or drawing a big X on it. They can also communicate this to you in writing. You can all agree that the agreement will terminate upon the occasion of a certain event or date. So, for example, you could put the agreement into place for 1 month or 6 months or 12 months, or you could have it in place for a certain thing, such as a surgery. And when that surgery is done and the person is recovered, then you are no longer the supporter, if that's written into the agreement. The only way you as a supporter can terminate that agreement is by submitting it in writing to the person you are supporting, unless you have somehow agreed for some other end date or end time in the agreement. The court could get involved and could end your agreement for both of you if you as the supporter are convicted of a crime involving abuse, neglect, or exploitation. If there is a restraining order issued against you to protect the individual from you, it will also be terminated. And if for whatever reason you may lack capacity in the future, your supported decision-making agreement for that individual may also be ended. Next, we'll discuss agreement basics. As a supporter, you can support somebody informally, meaning that you haven't written your agreement down, but you've both talked about it and you understand what the agreement is. Or you can put the agreement in writing. When it's in writing, it meets North Dakota law and there are protections in place. In order for a written SDM agreement to be valid, it has a few requirements. It must be notarized by one notary public or witnessed by 2 witnesses. To be a qualified witness, the witness must not be a party to the agreement, be at least 18 years of age, be competent, not be an employer or agent of a supporter in the agreement, and not be a creditor of the named individual. If you put the agreement in writing, there's no required format for SDM agreements in North Dakota law, aside from the witnessing or notarizing that we talked about on the previous slide. The North Dakota Protection and Advocacy Project has a SDM agreement template available on its website in PDF form. You can take that form and fill it out by writing on it or filling it out on your computer. And you can only fill out the parts that apply to you or add extra parts in, whatever works for you and the individual you are supporting. SDM agreements are not filed with a court or any other entity. They are to be kept by you and the person you are supporting. There are benefits and advantages to having the agreement in writing. The first is that if the individual has asked you to, as a supporter, to gather information for them, you can do so by having the individual you are supporting sign authorizations allowing others to disclose their confidential information or documentation to you as the supporter. You can only obtain the confidential information about the individual you're supporting with an appropriate written authorization. You can use this authorization along with the agreement to obtain information such as health records, education, or financial records. Having a written agreement provides liability protection for you, the supporter. Generally, if you are doing something in good faith, meaning you're doing it honestly and believing you're doing the right thing, you're not going to be liable for an action you take unless you are acting in a reckless manner, you are being grossly negligent, or you're intentionally committing misconduct. If your job as supporter is to show the agreement to other people, third parties receiving a copy of the SDM agreement should rely on the agreement unless there is a reason to believe that the individual you are supporting is being abused, neglected, or exploited by you, the supporter, or unless they actually know or have notice, meaning they should know, that the SDM agreement is invalid or it has been ended. Third parties are generally protected from liability so long as they are doing something in good faith and they are relying on the supported decision-making agreement. If you have gathered information for the person you are supporting, you can't allow unauthorized access to or give these documents, records, or other information about the individual to anyone else unless they have told you to do so. If you have questions about supported decision making or would like more resources, please visit the following website, www.ndpanda.org/resources/supported-decision-making. Thank you for learning more about supported decision making and how to be a supporter.